Bicoastal bit license. Does California law atone for New York's sin? California has passed the Digital Financial Assets Law, which requires businesses involved with cryptocurrencies to obtain a bit license. The law comes into effect in July 2025, following Governor Gavin Newsom's approval in October. Initially, in 2022, Newsom declined to sign the bill, citing its lack of flexibility for the dynamic crypto and blockchain industry. The law instructs California's Department of Financial Protection and Innovation to draft regulations applicable to various crypto entities, including exchanges, trading platforms, and mining operations. To acquire a license, organizations must implement robust KYC and AML protocols, maintain bonding and capital reserves, submit regular audits, disclose transaction data, and establish strong cybersecurity standards. The law places a temporary ban until 2028 on licensed enterprises dealing with unregulated stablecoins like Tether. This legislation is creating a new precedent and is compared with New York's bit license system. New York's bit license, introduced in 2015, regulates virtual currency activities within the state. Critics of New York's bit license argue that it holds crypto startups to more stringent standards than traditional financial establishments. To make the licensing process more accessible, New York introduced a lenient framework in June 2020, allowing prospective licensees to partner with an existing bit license holder. Despite this, acquiring a bit license can still be expensive and challenging, with costs starting at $100,000, not including legal costs and compliance rules. California's new law and New York's bit license system signify the ongoing struggle between crypto innovators and regulators. Critics argue that the legislation will have the same effect as the New York law, stifling innovation and pushing crypto companies out of California. They question the need for transaction data reporting and licensing decentralized protocols. There is fear that non-custodial wallets, decentralized app creators, node operators, and other Web3 participants may be negatively impacted by broad regulation. But supporters, including many industry stakeholders, say it is potentially less restrictive and more effective than New York's version. The law benefits from lessons learned and new research since New York's law was passed. It is seen as more comprehensive, providing clear guidelines and reducing regulatory uncertainty. It includes robust consumer protection measures that should enhance market stability, attract institutional investors, and boost consumer confidence in digital assets. As cryptocurrencies become more integrated into finance and Web3, states feel compelled to establish guardrails against volatility and misconduct. California's legislation could serve as a model for future standards. While at the federal level, moves by the SEC and CFTC have met resistance from Bitcoin advocates. Internationally, regulatory approaches differ, with Singapore taking a more open stance and China and India opting for hard ban. With prudent guidance, consumer welfare and crypto liberties can coexist, requiring rules that prevent demonstrable harm rather than blanket mandates. California's bit license law represents an attempt at balancing these imperatives, setting a precedent for future regulation that, paired with restraint and flexibility, could foster innovation while curbing abuse. Like and subscribe for more emerging tech and digital media content.